Welcome to the Deep Dives,
Mm,
where we provide the shortcut to being well-informed. When you think about the Roman Empire, I bet the first things that pop into your head are legions, maybe aqueducts, maybe some dramatic emperor.
Conquest and concrete, right. That's usually the focus.
Exactly. But the structure that really outlasted all of that, the thing that's still shaping the worlds you live in today, wasn't physical at all. It was, well, intellectual.
We're talking about Roman law, and specifically about this pretty small group of absolutely brilliant legal scholars, the jurists.
Names like Gaius, Ulpian, Papinian, Paulus, these are the guys we're focusing on today.
They were the real architects. They took what started as, honestly, a kind of confusing, ritual-heavy set of old rules
Right.
and transformed it, just through intense thinking, really, into a rational, systematic science. That's the key. Law as a science.
And that's our mission for this deep dive. We're deliberately skipping the usual battles and biographies.
No emperor gossip today.
No. Instead, we're going straight into the nitty-gritty. We're looking at the actual legal commentaries, the fragments of their thought that survive.
These are the sources that show you the specific rules, the procedural details they were working out.
And we want to pull out those nuggets, those specific examples that really prove how profound their legacy is. We're talking about the mechanics of their legal reasoning.
Exactly. Our sources show them tackling really fundamental questions, status, property, what makes an agreement binding.
And you see the shift, don't you? Moving away from rigid ceremony towards abstract principles, towards reason.
Definitely. Though sometimes they introduced incredibly specific rules too, maybe based on social rank or sometimes just sticking to the absolute letter of some ancient law.
So this deep dive is really about appreciating that intellectual work. It wasn't just military power or political maneuvering that defined Rome's lasting impact. It was this kind of thinking.
Precisely. The sheer brain power involved in building this legal structure.
Okay, so let's set the stage then. To really appreciate what these classical jurists achieved, we need to understand where Roman law started. What was archaic law like, generally speaking? I mean, based on comparing early legal systems.
Well, it was almost the complete opposite of what we think of as law today. The absolute defining feature was formalism, extreme formalism. Meaning the ritual, the exact words, the precise steps in any legal action, that was everything. If you messed up one tiny part of the procedure, if you used the wrong word in the set formula,
Your case was just gone, even if you had a totally valid claim.
gone, kaput. Didn't matter how just your cause was, the process was the substance, in a way. The how completely overshadowed the why.
So procedure ruled over substance. That must have led to a very different idea about proof and even individual rights.
Right. Oh, absolutely. Our sources stress that the whole concept of legal proof in these early systems was worlds away from ours. And things we take for granted, like an individual's power to just decide what happens to their property after they die through a will. Or even just the basic freedom to make any contract you want. These were actually pretty late developments, relatively speaking.
So early law was more about the group, the family.
Generally, yes. It tended to restrict what an individual could do on their own. The focus was often on the family unit, the clan. So the jurists, over centuries, had to kind of carve out the space for individual legal action and freedom.
And we can actually track that change by looking at the procedures themselves. You mentioned Gaius earlier. He's key here, isn't he, for mapping out these actions?
He's invaluable. Gaius gives us this amazing snapshot comparing the older, more cumbersome actions with the ones that came later. He talks a lot about the sacrament.
The sacramento, that sounds serious.
It was essentially a sacred wager. Both sides in a dispute had to deposit a sum of money, a penal sum with the state. They were literally betting on who was right.
Seriously. So if you lost the case,
You forfeited your stake. It went to the state treasury. Imagine the barrier to entry that created. If you didn't have the money for the wager, you couldn't even bring your case effectively.
wow, that seems incredibly harsh. So what replaced it?
Well, Gaius contrasts it with later, much simpler actions, like the iudicis postulatio, just asking for a judge, and the condictio.
Okay.
With iudicis postulatio, for instance, if the claim was pretty straightforward, like for a definite sum of money, and one side affirmed it and the other denied it, boom, you just applied for a judge right then and there.
Much simpler. No big wager needed.
Exactly. It bypassed that whole costly, risky ritual of the sacramentum, a big step towards more accessible justice, you could argue.
And the timing of these things was also very prescribed, wasn't it? There was something about a 30-day rule.
Yeah, that's another interesting detail showing the move towards system. In the older sacramentum process, even if you won, you might have to wait 30 days before you could actually enforce the judgment against the loser using a pretty rough procedure called manus iniectio, basically, physically seizing the person.
Right.
Then a law, the lex penaria, seems to have formalized a 30-day waiting period before a judge was even assigned in certain condictio cases. Before that, the judge was given immediately.
So standardizing the wait time, making it more predictable.
It's about imposing order, creating a system. And it wasn't just about time, it was about the source of authority, too. Gaius points out this really crucial distinction between types of judgments, judicia legitima and judicia imperio continentia.
Okay, what's the difference there? Sounds so technical.
It is, but the core idea is about where the magistrate's power, their imperium, came from. Judicia legitima were proceedings based strictly on the established civil law, the Fiolaisa civil. The magistrate's power was limited by specific statutes, by lex. These usually involved Roman citizens within or near Rome.
Got it. Limited by statute.
But judicia imperio continentia were different. Here, the magistrate's imperium was freer, less constrained by the civil law statutes. They were based more on the magistrate's administrative authority and often dealt with foreigners or cases outside the immediate vicinity of Rome.
So you've got layers of authority, statute-based law, and then this more flexible administrative power.
Exactly. And that layering, that shift from rigid rules towards something more flexible, based on administrative power or even abstract principles, you see, that mirrored perfectly in how the jurists tracked the development of contract law. They actually saw it as a kind of philosophical progression.
Oh, so?
They looked at the move from what they called real contracts, things like a formal loan where you physically hand something over, or a verbal contract spoken in a precise way.
Okay, based on a physical act or words?
Right. The obligation there is tied to the tangible thing, the act. The law first stepped in to say, okay, even if the form wasn't perfect, there's a moral duty here not to just back out. It recognized the obligation tied to the physical reality.
But then came the consensual contracts. That sounds different.
Completely different focus. Things like sale, lease, partnership, mandate. Here, the jurists identified that the obligation arose purely from the agreement, the meeting of minds, the mental attitude of the parties.
So not the physical exchange, but the internal agreement.
Precisely. Any external actions, signing something, shaking hands, were just evidence of that internal undertaking. This was a massive intellectual jump. Defining and categorizing this invisible thing, consensus, required incredible abstraction.
Moving from concrete ritual to abstract intent.
Yeah.
That feels like the core of their achievement.
It absolutely is. And that leads us to concepts that our sources actually label as uniquely Roman contributions.
Like what?
Well, the whole theory of natural law, aeseus naturale, the idea of universal principles based on reason, and maybe even more fundamentally, the concept of the vinculum juris.
A bond of law.
Yes, that abstract chain, the legal obligation itself, that binds people to do what they agreed to, separate from the physical acts or the specific words used. Defining these abstract bonds in a rational, systematic way, that's the jurists' enduring legacy. They were trying to build law on reason.
Okay, so moving from the abstract world of contracts and consensus to something very concrete in Roman society, the power of the father, the paterfamilias, this concept of potestas. The jurists had to create really specific legal tools just to manage this power, right? Especially getting a child out of it, emancipation.
Oh, the rules for emancipation are a fantastic example of how meticulous and sometimes bound by history the jurists were. Gaius lays it out in painstaking detail. To free a son from paternal power, the father had to go through 3 separate formal sales emancipations.
Free sales of his own son.
Symbolically, yes, usually to a trusted third party. But here's the kicker, the detail that really shows you how tied they were to the past.
Yeah.
If it was any other child, a daughter, or even a grandson or granddaughter under his power, it only took 1 emancipation, just 1 sale.
Wait, 3 for a son, but only 1 for a daughter or grandchild. Why the difference? That seems arbitrary.
It seems arbitrary to us, but it wasn't to them. It came directly from the ancient law of the 12 tables.
The foundation text.
Exactly. That law apparently said, very specifically, if a father sells his son 3 times, let the son be free from the father. It mentioned the son, and it mentioned 3 times.
And his jurists just stuck to the literal words.
They felt they had to. The 12 tables were almost sacred. So even though it created this weird asymmetry, they preserved the complex 3-step ritual just for the son because the foundational text demanded it. Legal literalism in action.
That procedure sounds unbelievably complicated. You sell him, he gets freed, but he comes back.
That's right. After the first mancipatio, the buyer would formally free the son using a procedure called manumissio vindicta. But legally, that just made the son revert back into the father's potestas.
So you do it again.
Do it again, second sale, second manumission, son reverts again. Only after the third sale did the son actually cease to be legally under the father's power. And even then, he needed one final manumission from the buyer to become fully independent, sui iuris.
Wow. That's an incredible amount of legal machinery just to follow an ancient rule, literally.
It shows the tension, doesn't it, between respecting ancient forms and adapting the law? You see the same kind of meticulous rule-following in wills and inheritance. Jurists like Julian, Ulpian, Papinian, they developed incredibly detailed rules for sorting out family estates.
Succession seems like it would be a minefield.
It was. And a key principle was protecting the family unit, the household. Julian laid down this fundamental rule about making a will. If a father had a son still under his potestas, he had to either name that son as an heir or formally, explicitly disinherit him, exheredate him.
You couldn't just leave him out.
Nope. Silence wasn't an option. If you just omitted him, the entire will was invalid. In utiliter testabitur, as the technical phrase went, the will just failed. You had to consciously address the status of everyone legally part of your core household.
Okay, that makes sense to avoid accidental disinheritance. But they also dealt with much more complex scenarios, right? Like conditional gifts. Papinian seems important here.
Papinian provides some really insightful analysis, especially with things called fideicommissa. These were basically trusts requests made to an heir, often confidentially, to pass on the inheritance or part of it to someone else, usually if a certain condition was met.
Like if you die without children.
Exactly, that was a common one. I leave my estate to you, but if you die without children, please ensure it goes to my nephew. Papinian tackled the question, what kind of child fulfills that condition? And he ruled that the birth of a natural son, one perhaps not born from a formal Roman marriage, would defeat the condition. The heir could keep the inheritance.
Hold on. A natural son counts. Not just a legally recognized heir. That feels surprisingly modern almost. Looking at biology over strict legal form.
It does seem that way, but Papinian was careful. He added that you still might need to consider the testator's likely intention. Was he thinking strictly of legal heirs, or did he just mean any biological descendant? It's nuanced. He also noted, interestingly, that for a freedman man, even a son who was born while the father was a slave but later freed with him would count. The law was adapting to the complex realities of Roman society, including former slaves.
And these fideicommissa, these trusts, they had their own technical rules too, but how you could even ask for them.
Oh, yes. The Senate actually passed a resolution about this. You couldn't directly ask your heir to make someone else your heir. That phrasing was generally invalid.
Why not?
It seemed to interfere too much with the formal rules of appointing an heir. But if you phrased it differently, if you asked the heir to restore the inheritance after they had legally received it...
So give up what you got.
Precisely. Please give the property you inherited to X. That was considered a valid fideikommissum. The obligation wasn't seen as appointing an heir, but as transferring property already acquired. It's all about the exact legal phrasing to make the mechanism work.
Finding the right loophole, almost. And this precision extended to things like dowries, too, making sure wives were provided for. Labio and scaevola are mentioned here.
Yes, protecting the dowry was important. There was a rule. If a son, after becoming independent, made a legacy in his will, giving his wife her dowry back, which was customary, that legacy was valid and had to be paid, even if the son wasn't actually his father's main heir.
So the wife's dowry was secured regardless of the main inheritance disputes.
It seems so. It carved out protection for that specific marital property. And Scaevola added another layer of detail, ruling that if a father seemed to want his daughters treated equally, a magistrate should ensure a younger daughter got the same dowry amount as her older sister had, taken from the estate before other claims, if that reflected the father's likely wish. Meticulous attention to detail to achieve perceived fairness within the family structure.
So the jurists weren't just organizing family law. As the empire went on, they were also involved in, well, formalizing social hierarchy, weren't they? Defining status based on rank and wealth, which had huge legal consequences.
Yes, this is a really stark aspect that emerges clearly in our sources, especially from the 2nd century AD onwards. The jurists helped solidify this crucial legal distinction between the honestiores and the humiliores.
Literally the more honorable and the more humble.
Exactly. It was an official legal division based on a combination of factors: birth, wealth, holding office, and it fundamentally changed how the law treated you. It stratified legal protection in a major way.
What did that mean in practice? If you were classed as humiliores, what difference did it make?
A massive difference, especially in criminal law. Many of the traditional privileges associated with Roman citizenship effectively became reserved for the honestiores.
For example,
Flogging, whipping. Originally, Roman citizens had a privilege not to be flogged. By this period, that privilege was largely restricted to the honestiores. If you were humiliores, you could be flogged for relatively minor offenses.
wow, and worse.
Much worse. The humiliores could face punishments like crucifixion, being burned alive, or condemned to forced labor in the mines, penalties from which the honestiores were generally exempt by law. Your social status literally determined whether you lived, died, or suffered excruciating punishment.
That's a profound erosion of the idea of equal citizenship rights. And even within the honestiores, there were levels, right? Like the decurions.
Yes, the decurions were the local town councilors, sort of the municipal aristocracy. They were at the lower end of the honestiores scale. There was even an attempt by Emperor Hadrian to give them extra protection. He initially ruled they couldn't face the death penalty at all except for parricide, killing a close relative.
Did that stick?
Apparently not entirely, but the general principle held that decurions, as honestiores, were shielded from the most degrading forms of execution, like crucifixion. The law was drawing these very fine lines based on your precise rung on the social ladder.
But even if you were high status, even if you were a magistrate with power, the law still set limits. Ulpian and Paul talked about when a magistrate could actually be sued for their actions, didn't they?
They did. The basic principle was that magistrates were forbidden from doing anything that amounted to a personal insult or injury. But there was a practical problem: timing and authority.
Oh, so?
If it was a top-level magistrate, someone with the highest authority, summum imperium, you generally couldn't sue them for an insult while they were still in office. The idea was not to hinder the functioning of the state's highest officials.
Unless there was fraud involved, you mentioned.
Right, fraud might be an exception, but otherwise you had to wait until they finished their term. Lower-level magistrates, though, could be sued while they were still serving.
Okay, that makes a certain practical sense. Protect the office, but not indefinitely. But what if the magistrate was just doing their job and someone felt insulted? Was there a defense?
Absolutely. Intent was key. If the magistrate acted in line with good morals, bonus moribus, and for the benefit of the state, then even if someone took offense, it wasn't legally actionable as an insult.
How could they tell?
The jurists said the judge had to determine the magistrate's true purpose. Was the intention to uphold public affairs, or was it specifically to affront the individual? It put a burden on the judge to assess motive.
And flipping that power dynamic, Ulpian specifically tasked governors with protecting the weaker members of society.
Yes, he really emphasized this. Ulpian wrote that it was a crucial duty of the provincial governor to make sure that powerful men, potentiores viri, didn't injure the humiliores. He even said governors needed to protect people who defended the humble from being hit with malicious lawsuits themselves.
So an explicit recognition within the legal commentary that the system needed checks to protect the vulnerable, even within this very hierarchical structure.
Exactly. It shows the jurists weren't just passively recording the hierarchy, they were also thinking about how to make it function with some semblance of justice, at least in theory.
Now let's look at some specific crimes. Papinian had a really interesting take on theft, specifically sequential theft, that seems to bring in a moral dimension.
This is a classic piece of juristic reasoning.
Okay,
Scenario. Man A steals something from the owner. Then man B steals the same thing from man A.
right.
Obviously, the original owner can sue man B, the second thief, no question there. But Papinian's point was, can man A, the first thief, sue man B for theft?
I mean, man A did have possession, even if wrongfully acquired, so maybe.
Papinian said no. Man A cannot sue man B for theft. And the reasoning is fascinating. He argued that the legal action for theft, the actio furti, requires the plaintiff to have an honest interest, honesta causa, in the property's safety.
An honest interest.
By definition, the first thief lacks that honest interest because he stole the item himself. His possession is inherently dishonest. Therefore, he's legally barred from using the theft action against the second thief, even though he might still be liable to the original owner.
So the law itself have a kind of moral filter built into who can use certain actions That's quite sophisticated.
It embeds ethics right into the procedure. You see similar complexities with insult, especially within a family. What if someone insults a son who's still under his father's power?
Who gets to sue?
Paul explained that both the father and the son acquire the right to sue. But interestingly, the amount of damages awarded could be different. Paul noted that the insult might actually be considered greater to the son if the son happened to be of a higher social rank than his own father.
Seriously. So the son's higher status makes the insult worse, even though it's the same act?
Apparently so. Status didn't just protect you, it could also increase the legal value of your dignity. The higher your rank, the more egregious an affront against you was considered in the eyes of the law.
And finally, on specific penalties, they also codified things like adultery, very precisely, timelines, consequences.
Yes, Ulpian and Papinian laid out the details. There was a statute of limitations. You couldn't bring a prosecution for adultery more than 5 years after the alleged act.
Okay.
And if a woman was convicted, the penalties were severe and specific. Loss of half her dowry, loss of a third of her other property, and then relegation, basically, exile to a separate island from her lover who faced the same exile.
Harsh.
Very. And significantly, in adultery trials, the law explicitly permitted the torture of the slaves belonging to the accused parties to get evidence. This was an exception to the general rules that heavily restricted using torture against slaves in cases involving their owners. It shows how seriously this particular offense against the family structure was taken.
Okay, let's shift gears to the world of contracts and business obligations. Despite all the sophistication we've seen, Roman law, particularly the older civil law, seemed to struggle with some concepts that are just fundamental to how we do business today. Paul points out a real rigidity when it came to transferring debts or obligations.
That's a key area. Roman obligations, at their core in the amicus civil, were seen as intensely personal bonds between specific individuals. And because the history of debt enforcement was so harsh.
Right, you mentioned the manus inietio, the physical seizure.
Exactly. Because of that harshness, the law was very reluctant to let a creditor just substitute someone else in their place without the debtor explicitly agreeing. The debtor had consented to this specific creditor with their known level of, say, leniency or severity. Forcing them to accept a new unknown creditor was seen as fundamentally changing the deal.
So you couldn't just sell a debt on, like we might today.
Not directly under the old civil law, no. It wasn't seen as a transferable thing, but as a personal relationship. So the jurists had to get clever to allow for the practical needs of commerce.
How did they work around it? Legal fictions again?
Pretty much. The main tool was something called a novating stipulation. A stipulation, remember, is that formal question and answer contract. Novation means creating a new obligation to wipe out an old one.
Okay.
So to effectively assign a debt, they used a specific form. Let's say you owe me money, and I want my friend X to be able to collect it instead. The stipulation would be directed at you, the debtor. That which you owe to me, do you promise that it shall be paid to X?
Ah, so the debtor promises directly to the new person, X.
Exactly. Your yes to that question extinguished the old debt owed to me and instantly created a brand new, identical debt owed directly to X. It achieved the economic result of assignment, but technically it was a new contract, respecting the old rule that the original obligation wasn't transferable. Ingenious, really.
Very clever. And they had a similar workaround for another problem. Promising something for the benefit of a third party, which wasn't generally allowed either. The penal stipulation.
Right. The basic principle was that a contract only created rights and duties between the contracting parties. You couldn't normally enforce a promise where the benefit was solely for someone else outside the contract.
So how did the penal stipulation fix that?
You framed the promise as a penalty payable to yourself if the main action wasn't performed for the third party. So instead of, do you promise to pay X, it would be, do you promise to pay me 100 sesterces if you do not pay X 100 sesterces?
I see. So if the debtor doesn't pay X, I can sue them for the penalty.
Precisely. It gave the promisee a direct financial interest in ensuring the third party received the benefit, effectively allowing them to enforce it indirectly. Again, using the formal structure of the law to achieve a result the core principles didn't easily allow.
These workarounds highlight a really significant conceptual limitation, though, especially when we think about modern business.
Yeah.
The idea of agency. Someone acting legally on your behalf. Gaius draws a sharp line here concerning mandatum, or mandate.
Yes, this is absolutely crucial and often misunderstood. Mandatum in Roman law was not agency as we understand it today.
Why not? What was the difference?
Under the civil law, you could generally only acquire rights or incur liabilities directly through people who were legally under your power, your children in potestas, or your slaves. Anyone else, any free person acting on your instruction, your mandatory, was considered an extraneous persona, an external person.
An outsider to your legal sphere.
Exactly. So if you asked your friend, your mandatory, to buy a farm for you, and your friend made the contract with the seller, legally, at civil law, that contract was exclusively between your friend and the seller.
So I couldn't sue the seller if they backed out, and the seller couldn't sue me for the price.
Not directly under the civil law, no. Your friend bought the farm legally for himself, even if everyone knew he was acting for you. He was liable for the price, and he acquired the ownership initially. You, the mandans, were technically a third party to that deal.
That must have been a massive headache for any kind of complex business or trade.
It was a huge impediment. As Roman commerce grew more sophisticated, this clearly wasn't sustainable. So what happened?
The praetor stepped in.
Yes, Praetorian law, that more flexible body of law developed by the magistrates, had to create exceptions and patch the gaps in the civil law. The praetor introduced special actions that allowed the mandans, the principal, to be sued directly on contracts made by their mandatory in certain common business situations.
Such as?
The most famous were the actio instatoria, if the agent was managing a business for you, and the actio exercitoria, if they were captaining a ship you owned. In these specific, defined cases, third parties could sue the principal directly.
So they created specific legal actions for common commercial scenarios, but without actually overturning the basic civil law principle that the agent's contract was their own.
That's the essence of it. It was a pragmatic fix. Later jurists, like Papinian, even suggested maybe extending these Praetorian actions more broadly to cover all mandate situations. But the underlying formal separation often remained. The agent was still primarily liable, and often the principal would technically have to get an assignment of the right to sue from their own agent to go after the third party directly. The system was always sort of working around its own core premises.
It really highlights the jurist's role, doesn't it? This constant effort analyzing family structures, defining status down to the level of punishment, wrestling with debt, finding ways to make commerce work despite conceptual limits. It's incredible intellectual undertaking.
It really is. They were building a coherent system out of disparate parts, ancient statutes, magisterial edicts, philosophical ideas about reason and nature. It demanded synthesis, critical analysis, and above all, incredibly precise definition.
They were essentially architects designing a system of thought. Yeah, creating legal science through categorization, definition, logical deduction.
Absolutely. And comparing their approach to, say, earlier lawgivers is quite revealing.
Like the Greeks. Solon, for instance.
Right. When you read about someone like Solon, the emphasis in the sources is often on his character, his actions aimed at social reform within Athens, his moral pronouncements like avoid excess. He was legislating for a specific community, often tying laws to moral virtue.
And the Roman jurists.
Their focus seems different. They were building a more abstract, transferable toolkit of legal concepts and categories, principles of obligation, property, status, defined in a way that could, in theory, apply to anyone, anywhere within the system. It was less about legislating specific virtues and more about creating a rational structure for resolving disputes and organizing society. #outro.
So wrapping this up, the big takeaway really seems to be how these jurists took abstract ideas. What is a debt? What defines a family for legal purposes? How can ownership be transferred? And applied this intense methodical analysis. They used precise definitions to build, layer by logical layer, this incredibly sophisticated and adaptable legal system.
And that system, that rational, systematic way of thinking about law, became hugely influential. It wasn't just Roman roads or armies that conquered the world, in a sense. It was this intellectual framework. When Roman law was rediscovered in the Middle Ages, it was the work of these jurists, their writings compiled in Justinian's Digest, that formed the foundation for legal systems across continental Europe and beyond.
It really underscores that intellectual labor, the power of analysis and definition, was just as crucial to Rome's enduring legacy as any emperor or general. Their feat was one of systematic thought.
Absolutely. Modern lawyers, in many ways, are still standing on the shoulders of these intellectual giants.
And that leaves us with a final thought for you, the listener, to consider. We've touched on how the jurists distinguish between different types of law: aetius civil, aegius gentium, aetius honorarium, and crucially, aetius natural law. Now, if the theory of natural law, this idea that law isn't just arbitrary rules, but should strive towards principles based on universal reason, if that's considered a uniquely Roman concept, what does that suggest about the fundamental belief driving these jurists? Were they just technicians, or did they see themselves engaged in a deeper, almost philosophical quest to uncover universal truths about justice through their methodical, rational approach?
A really profound question about the ultimate aim of their intellectual project. Something to think about.
Indeed. Thank you for diving deep with us today.